last session is a pair of papers on patent litigation. And so first we'll hear from Tommaso.
Okay, are we still doing the, okay, I'll try. Okay, thank you for inviting me. It's a pleasure to be here, and thanks to all the speakers, because it was really great today. I hope I will not bring down the mood too much with this intervention. Okay, so this is a paper that is very timely for me to present it here, because this is a paper that's been blessed or cursed with a constant stream of new data available and technical improvement that forced me to go at least 3 times, stop instead of polishing and wrapping it up and say, no, wait a second, with this data, I can do so much better, and so on. So today you are seeing hopefully one of the last iterations of of me stopping. And so when I say that your feedback and comments are very welcome, I mean it, because I'm redoing the entire estimation. So please be merciless and tell me anything you think I should be doing or you find interesting. So as the title suggests, we're in the litigation session, and this is about bargaining for settlement in a context of US patent litigation. Now, you're in this session, so probably you're a sympathetic audience to the idea that patent litigation might be interesting on its own right. But even if you're not, I just want to mention that in the last 15 years, patent infringement cases have been almost doubling in the US. And this may be concerning because those cases are incredibly expensive to litigate, with a median cost of 1.6 million per party involved, even before we get to the point that any amount is transferred, if any, is transferred in court. And this can be concerning because the rise in patent litigation has been mostly due to the increase in filing of patent infringement cases by patent intermediaries. Some were patent pools, but mostly by patent assertion entities, whose entire business model is to purchase IP, enforce it, and monetize it with a threat of litigation. Now, this is concerning because there is a general idea among practitioners and law scholars that many of those cases that are filed are actually frivolous. And what I mean by frivolous is that they are very unlikely to succeed in court, but threatening enough to be able to extort settlement revenues. And yet at the same time, the current administration, some judges and some congressmen are trying to push the idea that patents are actually too weak and not easy enough to enforce or to obtain an injunction with. So the question of whether we should make patents stronger or not, and whether those are taxing innovation, is an empirical one. Turns out it's a very hard one to solve, because the vast majority of those cases end in settlement. And when they do, well, we don't know who would have won, and we don't know how much has been transferred in those settlements, because they're sealed by NDA or otherwise unavailable. So this empirical challenge motivates this paper, as well as the title of the paper itself. So I will take a structural approach and I provide a new model in order to solve the selection issue. And by unsealing the settlement, I will try to do exactly that. I will try to get to, as a primitive, to a distribution of ex-ante probability of winning for the cases. So probability of winning at filing. I will call that strength of the case. I will call it quality of the case. That's what I mean, ex-ante probability of winning. And I will try to get to the best estimate I can get, given the information available, to a distribution of how much is transferred in those settlement cases, so that we can better understand what is the cost to those cases, settlement cases that settle. So that we can better understand what is the overall burden that defendants are facing. And incidentally, maybe I'll learn something about how judges make decisions and how some courts might be more favorable to plaintiff than others. And of course, it's a structural model, so I cannot resist the temptation to, once we have the parameters, make some counterfactuals. And there are 2 very natural counterfactuals, because 2 ways have been proposed by law and economics scholars to try to mitigate, to a certain extent, this allegedly abusive patent litigation. One being reducing the scope or the flexibility of plaintiff in deciding the venue in which to sue, so banning or reducing forum shopping. And on the other, and we will hear about it in the next presentation. And the second, second proposal has been to increase the scope for cost and fee shifting. So make the loser pay, essentially. Okay, so just to give you a preview of what I'll be doing, I will be presenting a new model of bargaining with asymmetric information and information arrival. And the key information that I will need to take very seriously, because it's one of the few things we can actually observe, is the timing at which different events occur during the litigation. And to give you a preview, the result that I'll be able to show, given the estimation of the case quality, I'll be able to make make statements such as 60% of the cases of the 85% of cases that end up in settlement, 60% of those would have lost in court. So defendants had to pay. In court, they wouldn't have to pay, the defense had to pay a positive amount. In court, they would have been paying zero. And if we look at specifically the cases filed by patent essential entities, indeed, those two seem marginally more frivolous than the others. And how does this amount in terms of cost for the defendants? Well, out of the $1.3 billion we see every year paid in court by defendants, there's actually a hidden $24 billion that are paid in settlement. And on top of that, with my given my estimates, I estimate almost 23 billion just in cost of litigation paid by the defendants. And if we sum it up with the cost for the plaintiff, we get to a whopping $43 billion each year that are paid, which is around 6 to 11% of the entire expenditure in R&D, private expenditure of R&D in the US. Coming to the counterfactual, I will also be able to say that forbidding forum shopping seems to be, according to my estimates, a no-brainer. With no direct, with no drawbacks. Well, fee shifting can in principle decrease welfare depending on how we define welfare. Mainly, fee shifting is great because it can reduce the amount that is paid by defendants, can reduce filing of the worst kind, but on the other hand can make defendant less willing to settle, even in cases that possibly are worth settling for. I will skip the lit review. I will just say that there is a contribution to the theoretical literature on bargaining under asymmetric information, as well as the IO literature concerned with its estimation. And many people can see their names on the slides or in the paper for what concerned the empirical contribution on the literature, economics and law literature on IP and the cost side of IP. Coming to my data, my main data source will be Lex Machina. Lex Machina is a great website that takes the information from Pacer and augment it with their own sources and allow you to obtain a lot of specific information, granular information on each case that is filed in federal courts in the US. Now, part of the reason why I'm redoing the estimation is because initially it was incredibly hard to get docket by docket information or the text of each docket. It was basically unfeasible. And now recently, due to the pressure of I like to think myself and some other scholars into the topic, they made it available through API, the download of the text and the text descriptions of each individual dockets that he filed in these cases, which is fantastic because as we learned, we have incredible tools to extract information from text right now. So I'll be seeing if I can get even more credible estimates once I augment it with additional observable. And most importantly, I'll be able to timestamp every event that occurs, and I'm already able to do it. Given that, I just augmented with the patent USPTO data and then firm level data from CRSP. So this is how I see, this is the moment where I offend the lawyers. This is how I envision patent litigation. For the economist, my main message here, you should not be thinking about patent litigation as a streamlined linear model where parties meet, and if they don't agree, they immediately see a judge and everything is resolved in one shot. This is not what's happening. For the lawyers, I'm being oversimplistic in mentioning that patent litigation specifically has many points in which the case can immediately terminate, simply because on top of mistakes in the claim response, simply because a party might be unable to prove the specific meaning of a patent, or the plaintiff might be able to obtain an injunction and makes essentially litigation meaningless, and so on and so forth. So I'm envisioning patent litigation as more a game of two players that are constantly at risk of failing to meet some requirement of litigation. If they do, essentially the game is over. And that can happen not according to a very clear and linear timeline. As a matter of fact, if I just, oh, come on. Yeah, okay. No, I need to show you this. Yeah, that's a problem. Okay, good. This is all the way in which a case can end. I can show you this picture. This is a picture as on the x-axis time. I can show you more or less the same picture with pages of PDF written by a lawyer. And this is also my notion of time can be in docket time, I will call it, or in chronological time. And as you can see, these are all the ways that in which a case can end. Trial is just two of them. Of course, they tend to happen a little later, but there's a lot of overlap. You can have dismissal at time, even for comparable cases that happen for way later the time in which a trial was granted and won by one of the parties. If I aggregate a little bit to make similar outcomes come out together, the picture remains the same. There's a clear difference in the settlement, but that's the endogenous outcome. Of course, the endogenous outcome is not one of the risks we are trying to, the competing risk we are modeling. So my extra step, that's where I offend the lawyers, is just doing this. Actually, only three things can happen. Either they settle, one party win, or the other party win. And this is what I will have in mind. Now, I would be clicking this button, but it doesn't work. So, fantastic. Okay, lawyer offended, not too much. Okay, so that's what I will be thinking. And if you have this idea in mind, then the model setup should be relatively straightforward. I have two players, a plaintiff and a defendant. The plaintiff sued the defendants for a known amount pi. Now, it doesn't matter that the amount was determined. There can be uncertainty in there, as long as both parties know the distribution of that amount. The asymmetric information instead is coming from what I call the quality, which is the probability, the Poisson rate at which at each point in time the plaintiff has a chance to win during litigation. And the plaintiff naturally knows his own strength, while the defendant does not. But it has a prior on that, and it will try to update it by making a series of sequential offers. Litigation occurs in continuous time. For each instance, litigation parties are paying cost CD and CP respectively. And while litigation is going on, three things can happen. One party can win. That occurs with a Poisson rate that depends on the strength of the case. Stronger cases are more likely to succeed to obtain the injunction. The defendant wins. Well, this will depend on the characteristic of the case and the court and the judge and so on, but it will be independent from the strength of the case. You can imagine the parameter rho as being the standard of proof, the amount of evidence that the plaintiff need to keep providing during discovery in order to keep the case going and not having it dismissed. And finally, if neither thing happen, party eventually meet. This will occur with an arbitrary distribution at intervals of tau with an arbitrary distribution. And when they meet, the defendant will be able to make a settlement offer. If the offer is accepted, great. Transfer occurs, the case end and settlement happen, and each party paid their own cost. If the offer is rejected, instead parties go back. Now you see also drop in the strategy action of players. This will never happen in equilibrium. But it is important for the outside option. Okay. Any question on the idea? Fantastic. How much time do I have? Okay. So in this case, okay, fantastic. Then I can say something. I will consider Markov perfect Nash equilibrium with respect to the defendant's belief as my notion of equilibrium. Now you're thinking I'm doing an empirical work. Why I'm making my life so horrible by using an infinitely dimensional state space? That's a terrible idea. Fortunately, two propositions in the paper came to my rescue. First one is a common to those type of model of bargaining. It's called the skimming property, that essentially says if at any point a plaintiff would like to accept an offer, then every weaker plaintiff would also like to accept it. If at any point a plaintiff would like to reject an offer, every better plaintiff would also like to reject the offer. Which means we can also, for any offer, we can characterize a cutoff strategy, which means that instead of solving for all the offers and all the acceptance strategy of the plaintiff, we can just have a defendant choosing with which type to settle at each possible time. So we can embed the plaintiff problem into the defendant problem. we still have an infinitely dimensional space. How do we solve that? Well, it turns out that our belief update allows only two numbers to perfectly characterize the distribution of the posterior distribution of cases. What two numbers? Well, who is the worst type that is still hasn't accepted any offer? Second, how much time has passed since you start litigating? Okay? And now all of a sudden we have a two-dimensional state space that makes it feasible for me to solve things. Now I would love to click this button and show you a GIF of our belief update over time, but I will just describe it. Imagine every time an offer is made and rejected, the defendant learns something, learns that they're definitely not dealing with the worst type of plaintiff because they would have accepted. Every time a defendant see the plaintiff failing to win, then also realize that they're not dealing with the best type of plaintiff because the best plaintiff would have succeeded. Which force prevails? Well, depends on the parameters. So this model allows for non-monotone evolution of belief over time, which is good because I have to take time relatively seriously because it's my main observable. This is a lot of words. I promise some of them are clever. They say, essentially, that I can solve this model. It has an equilibrium always exists, and it is unique. Coming to estimation, what do I do? Well, the parameters, just a reminder, are the value at stake, the distribution of quality, f of lambda, the frequency of meeting, arbitrary distribution g, the cost parameter for the two parties, and finally the court standard of proof, the hazard rate of losing for a plaintiff. I need to make a normalization. As a matter of fact, the model is not identified, it cannot identify separately pi and the two cost parameters. But this is a feature, not a bug. And the reason why is that if you don't believe the way in which I'm getting pi later, it's fine. You can still believe the way in which I get, you can still believe to my statements about the relative cost. So C divided by, the C is divided by pi, which is nice because you might have some issue on how I get to pi. That's great. Second normalization, I can choose what is time. I already mentioned it. Time can be pages of PDF or pages or days days in the year. Then I just choose a flexible beta distribution for lambda, and then I proceed as follow. Take a court, take a type of patent, take a plaintiff, whether they're PAEs or not. Decide who's the victim, who's the defendant, whether they're a large firm, a small firm, and so on. Maybe we can even bin it for size, but I need to make a discrete choice here. I need to bin cases together. Take a sector. I have to assume that all cases within here can be different, but they're drawn from the same distribution. If I assume that, then I can correctly estimate by Kaplan-Meier estimator the hazard rate of the three possible events, settle, win, or lose. And from there, since I have a model that gives me unique prediction for those settlements, I can do a simulated GMM to solve for the parameter. Now you see the new in red, I can do much better actually. Thanks to the data, the timestamp on each event, I can do better than that. And I can even move to an estimator of quasi-maximum likelihood, because at that point, I don't need to rely on just the hazard rate. I can see when an offer is rejected. I don't know what the offer, but I know that an offer could have been made at that point, wasn't made. Both lawyers were in the same room, and they did not agree to something, and that is information for me, okay? I would click to the button, but I can't, so let's get to the estimation. I normalize pi to 100, because why not? So that CP and CD can be seen as percentage, so cost as a percentage of the whole value at stake, okay? And then we see some familiar pattern. First of all, the rows are very different across different courts. Now you're seeing the top court for frequency, for cases filed. And we immediately see that the Eastern District of Texas has the lowest standard of proof. In other words, you really want to be a plaintiff in the Eastern District of Texas. You really don't want to be a plaintiff in the Central District of California. Another thing we see is that take all the cases, take the distribution across the different type of patent and so on. Take the average quality that I estimated in each one of those, and that's what I'm seeing on the table. On the green side, you see the average quality of cases filed by practicing entities. on the red, you see the average quality of cases filed by patent assertion entities. Very nicely, you see that in each district, the average quality of cases for PAEs is strictly lower. And I will show you something more in a second. But first and last, what I find interesting here is that if we look at the sum of the cost parameters, again, average sum of cost parameters in the top districts for cases that were filed by PAE and cases that were filed by PE, we find that the total cost as a fraction of the value at stake for patent assertion entities is much higher for PEs. Is it because all of a sudden cases become more expensive when PE file? No, simply because stakes are lower. Probably the pie is smaller. Which supports the idea that many PAEs indeed follow a bottom feeder strategy. As for this picture, it's interesting because yes, this table is telling you that on average patent assertion entity cases are worse. But if we look at cases within the computer and communication sector, we actually see that there is a reversal. So on the left side, you see that there is stochastic dominance in the quality of practicing entities cases. So for each level of probability, real firms to file stronger cases than patent assertion entities. But if we go on the type of cases in which the PAEs are specialized, they are just better at picking. Among the worst cases, they're better at picking them. As for how I get to the dollar amount, I have to rely on the cases that do transfer in court and then extrapolate. That's why you might have some issue with it. Counterfactuals. Conditional fee shift. So two extreme of the line. American rule means there is no fee shifting at all. British rule, the loser pays all. What I do, I have a flexible specification and I consider conditional fee shifting, where two extremes of the lines are embedded in this specification. So I can say what would happen in terms of filing, average settle amount, and cost for the defendant if we were to take my estimates and all of a sudden we start imposing fee shifting in those three regimes. The American rule is what we estimated, so nothing changes. With moderate fee shifting, we see a drop, a halving of the settlement that is paid by the defendant, and also a drop in filing. And finally, but unfortunately, we see an increase in the average duration of cases because for two reasons. Partly, one is mechanical. The worst cases are not being filed. So better the plaintiff are more willing to fight because they have a better case. And the other part is not mechanical. Defendants know that they have a chance of getting their fees back, and so they're more willing to fight. British rule is a more extreme so there are, depending on what's your welfare criterion, you might not want to go all the way to the British rule. And then, this is a picture you'll see again, I imagine soon. This is a counterfactual on forum shopping. As you know, that in 2020, 23% of cases were filed and handled by one judge that you see in the picture. And there is a lot of, I showed you evidence to suggesting that there is a lot to gain by choosing the venue, just based on the rows. Suppose we take the cases for which I can identify the headquarter or where listed firms operate, and I can estimate what is the quality of the case that was filed, take the case filed against listed firms. Find those that were filed in venues that were not venues where the listed firm was operating. And then let's see what would happen if we were to force the plaintiff that filed those cases to file in the district where the listed firm has its headquarters. And this, interestingly, of 8,000 cases filed against publicly listed defendants, 611 were forum shopping cases based on this definition. Most of them were filed by PEs. And again, I'm not imposing in the data, it's just coming up by a business. And guess what? They were exactly filed in the court that I identified to be the court where you really want to file. It was very good for me because I'm really not putting any structure to force it to be the case. I was very happy when I saw that. And guess what? Those were cases that should have been filed in Delaware or California where you really don't want to be a plaintiff. So what happens if we force patent assertion entities to file where they should have filed based on this definition, well, there will be a drop in case files, about 6%, but most importantly, a massive drop on the settlement amount the defendants will have to pay. Okay? And in terms of duration, we will not see significant increase in duration. So I don't know what's my time, but I did a thing, and I did another thing. No, I introduced a new model of bargaining with asymmetric information arrival. And the key thing I wanted is to have the belief to evolve credibly or interestingly over time. And so I created this flexible model. I made stoic assumption, hopefully digestible stoic assumption, in order to retrieve an object that is just very hard to get, being the distribution, ex-ante probability of cases, ex-ante probability of victory for plaintiff and case filed, and the settlement amount for the cases that do settle. I find evidence that confirms the frivolous side of so the camp suggesting a case filed by pattern association entities are more frivolous. However, I see some evidence on skill from the pattern association entities in their ability to pick the best among the worst cases. In terms of counterfactual policy, please let's ban forum shopping, and fee shifting should be on the table, but we have to be mindful. Thank you very much.
Thank you. I'm going to put one down here because I'll end up throwing them across the room. I think this is the safer bit. Yeah, that's good. All right. Did I close it? No, it's right here. Somebody said there's a full screen button somewhere. Oh, yes. All right, perfect. Thanks for having me. Thanks for being the last paper. Thanks for the organizers for putting this together, having everyone on the program. Thanks for the discussants of spending time reading papers, coming up with thoughtful comments. This is joint work with Christian Helmers and Brian Love. We've changed the title a little bit. It's now called Randomly Albright. That judge you saw in the picture, that is Albright. And we randomize Albright. And we look at the end of judge shopping in the Western District of Texas. And so let me say a few things about what we want to do in the paper. First of all, we start off with this question, do plaintiffs actually get to choose their court or judge? So that's the idea of either forum shopping, you get to choose somehow the forum or the venue in which you file, or you actually get to choose your judge, not just the forum, but the actual judge, and that's going to be at the core of this paper. And if so, what's that choice worth? We want to better understand why is it that why plaintiffs have an incentive to try and choose a forum or actually choose their judge, and what do they lose when they lose the ability to do so. And that's the point of banning forum shopping or limiting judge shopping. The problem, though, is this is hard to pin down because studies of litigation are typically riddled by selection. If I want to understand what happens, how do firms benefit from a judge by just looking and comparing the outcomes or the outcomes of cases under one judge with the outcomes of cases of another judge, I'm gonna struggle with some selection. So what we do here is we exploit an episode of random judge assignment to answer these questions. And we have three main results, and I'm going to give us a preview here quickly. When the preferred judge is no longer assigned with certainty, so instead of knowing exactly where you're going, and you really love that judge or you really love that forum, and all of a sudden that's no longer assigned with certainty, but somebody flips a coin, then we see the following. We see case filings drop and plaintiffs leave the venue. They don't just relocate to other venues, they actually stop filing certain cases or some cases. The exit is driven by high value or low quality patents, and those are the ones that are where the most future revenue is to lose if the patent happens to be invalidated. So the paper has a little theory model. I'm not going to go into the model today, but the theory model gives us that prediction that those two types of patents, high value and low quality patents, are most exposed by that kind of ruling. And third, we see why the judge was preferred. The judge's cases are scheduled faster, and they have fewer challenges that challenge the validity of the patent. Joachim, you have a question?
Low
Yes.
quality, is that low legal
Yeah. So we try to proxy that empirically, but that would be exactly what we have in mind. There is a higher probability of the patent actually being invalidated. Yeah. So it's not the quality of the invention; it's the quality of the patent. All right. So forum shopping. Plaintiffs prefer some courts to others, and they will strategically select where to file their suits to exploit that heterogeneity across judges. So that's the idea of forum shopping. We see here the courthouse, I think that's in Marshall, that's the Eastern District of Texas. At some point, Samsung decided, we're going to pay for ice skating rink. This is Texas. There aren't that many ice skating rinks in Texas. Lots of cases being filed there. I don't know if this was their attempt to try and sway the jury pool in one direction or the other, but lots of these cases being filed. We just saw them in the paper. Burden of proof very low. That's where you want to go as a plaintiff. That resulted, so this idea of forum shopping or judge shopping results in concentration of cases in single courts. We see this in a lot of different types of cases. Chapter 11 bankruptcy filings, challenges to FCC regulations, immigration removal proceedings, but also patent assertion, as in the Eastern District. And judge shopping takes this to a whole new level. And at some point, the media started picking up on that. There is an article in The Economist. It's the new economic order, how judge mandering is eroding trust in America's judiciary. The assignment of judges to cases should be random, not political. Some other news articles here. Federal courts now move against judge shopping, an article in Politico, all the way down to the U.S. should abolish judge shopping. So as much as it got into the spotlight, the media started picking this up. Debates in Congress to the point where the U.S. the Judicial Conference of the United States came down with a recommendation recommending that federal district courts should select judges at random for lawsuits seeking to impose or rescind national injunctions. It's just a recommendation. It's not a binding guidance, and judges in the Northern District of Texas and the Fifth Circuit have at that point already spoken out in opposition to the recommendation. You're not telling us what to do, more so to speak. What we're asking in this paper, how effective can random case allocation actually be? So what do we learn or what do we gain from that type of random case allocation? So we exploit this local policy change to random case allocation in the Western District of Texas, and that's Judge Albright, where we go from one judge with certainty to a randomly drawn judge. And the results of our paper show the effects of judge shopping and the end of judge shopping on both case filings and decisions of plaintiffs to abandon the district. So not just plaintiffs staying in the district, just filing fewer cases, but overall plaintiffs deciding to leave the district and filing somewhere else. And we can also show that random case allocation allows us to study the causal effects of a judge on case proceedings and outcomes. Because a case is being filed and then a judge is randomly assigned, and we can look at how that affects case proceedings and outcomes based on the judge. This is our judge. So Judge Albright in the Western District of Texas. In 2021, Albright presided over almost 25% of all U.S. patent infringement cases. Let's start with a little bit of background. I had a dream, the background of the background. I had this dream a couple of weeks ago that he'd be here. Maybe next year. He's stepping down. Maybe next year, invite him as a practitioner. And then, because he's got a fan community now. All right, so Judge Albright, he was nominated to the seat in the Western District in January 2018 and was confirmed in the September of 2018. The Western District of Texas spans more than 50 counties, 2 time zones, and 7 divisions. This is a pretty big district. He decided to locate his judicial chambers in what was then the unoccupied Waco Courthouse. It's a beautiful building, 1920s, I believe. Waco is in McLennan County. If you've ever driven through that area, don't speed. You do get speeding tickets. I speak from experience, but it's a beautiful region there. It's really nice. So he chose to locate in the then unoccupied Waco Courthouse, which made him the sole district judge in the Waco division. So Albright would preside over all civil cases that were filed in the courthouse. And then we asked, what can a single judge actually do? Well, the U.S. district court system gives them some discretion over what can happen in the district. So there are more than 600 judges across 94 districts. Within a division, new cases are typically assigned at random. And if a division has multiple judges, cases would typically assign at random to one of the judges. The venue itself is chosen at the district level. So a firm can be sued, and we heard that earlier, a firm can be sued where it's incorporated or has a regular and established place of business. That also means that San Antonio is part of the Western District of Texas. Austin's part of the Western District of Texas. There's a lot of business happening there. Waco is really not that big, unless you have patents that relates to beverages. Dr. Pepper Snapples, I think, has its headquarters in Waco. So, but Austin, San Antonio, part of the Western District in Texas, there's a lot of business happening there. A lot of cases can be brought in that district. The actual case assignment is within the division. So what judges do is they do follow federal rules, but they also follow local rules, and that adds some procedural norms of their own, especially when it comes to standing, scheduling, discovery orders. So there's some discretion the local judges have. And it's these idiosyncratic practices, and not necessarily a bias. Judges may be biased, may not be biased, but it's these practices that shape speed, order, the cost of litigation, and that can influence the outcomes. And that can influence how firms, how plaintiffs perceive the judges and how popular the judges are for them. Albright made it pretty clear, come to me. So he advertised his courtroom. Albright, and we take this from a quote from a publication, Albright let it be known in no uncertain terms that he would like his Waco courtroom to become a hub for IP cases. 25% of all newly brought infringement cases is a testament to that. He introduced several practices that are favorable to patent owners, especially early claim construction hearings to speed up trials, trying to have cases reach trial within 18 months' time. There are other factors that were raised by legal commentary. Albright was unlikely to grant motions to stay litigation or pause litigation. He was reluctant to invalidate patents on subject matter eligibility grounds, and he was not very likely to grant motions to transfer cases to other courts. If the defendant wanted to move this to another court, he would say, not happening. So great, now we can go shopping. And Waco does become a patent hotspot. It had about 17 filings per quarter before he joined. The Waco division only had 3 in the year prior to his arrival, and it went up to 140 new patent cases per quarter in the 3 years that followed. So in 2021, he had about 25% of new cases. Albright's availability induced the filing of hundreds of cases that otherwise would not have been filed. That's a finding by Christian Hevels and Brian Love in another paper. They're just cases appearing from nowhere hadn't it been for Albright. But somebody got fed up, and that was Garcia. That's the Chief Judge. On July 25th, he came down, 2022, he came down with the order revising the district's case assignment rules. He said that cases filed in the Waco division would be assigned randomly among the district's 12 judges. Patent cases filed in the Waco division would now be randomly assigned to one of the entire district's 12 judges. So what we do in the paper is we ask, how does random case allocation affect patent case filings and why? So which types of plaintiffs move, which types of patents move, and what are the causal effects of a specific judge on the proceedings and the outcome? All right, so that was a lot of background. 10 minutes-ish? 13. All right. Empirical approach and data. We do this in 3 steps. First, we look at the effect of random case allocation on cases that are filed in the Western District of Texas relative to all other district courts. So here's where we're difference in differences, a DID design. And our sample is all cases. So Western District of Texas against all other districts. Second step is we then look at the effect of random case allocation on filings at the plaintiff level. Here's where we look at the sample of all plaintiffs that file cases in the Waco division. We want to better understand, do they file more or do they leave the division? And those who stay, do they happen to file more or less? And then the third step we're taking is we look at the effect of random case allocation on case proceedings and the outcomes. Here the sample is all randomly assigned cases after that July 25th, 2022 order. So it's a relatively small sample of cases that were brought after the order, and we look at what happened to when a case is randomly assigned to Judge Albright. All right. As data construction, we look at cases that were brought between July 2017 and December 2024. The main analysis has cases starting in 2021. We have outcomes all the way through August 2025. A number of different databases that we look at. We have case-level data, firm characteristics. We have the NP status, similar to Tommaso. We have patent-level characteristics. We look at litigation events, and we have assignment type. Was a case randomly assigned, or was it a related case? I'll come to that in a second. All right, results. Pictures and some tables, and we have the three big questions. So what does it do to case filings? Which types of cases are affected? And can we say anything about the causal effects on case outcomes and proceedings? All right, let's look at the raw data first. So this is a picture of the monthly case filings, and we see a drop in July 2022. The black line are the cases, monthly case filings in the Western District of Texas. This is when Judge Albright joined. This is when the random case assignment order came down. This is the drop in cases filed in the Western District of Texas in the months following the random case order. There are two lines. There's a black line and a gray line. The gray line includes related cases. So the random case order applies to new cases. Related cases, that's a case that, a file case that relates to an earlier case. Those would still be assigned to the same judge. No, that judge has some prior knowledge of what's happening in the patent. So those cases would be assigned to the same judge. If we include the related cases, the drop's a little small. If it's just the new cases, that's kind of the drop we see. The Waco division cases assigned to Albright, that's a bit of a sanity check. Before the case order, all cases in the Waco division were with Albright. He was the sole judge. There was nobody else. And it dropped to about 11% of unrelated new cases after the order. These are the average number of monthly cases each of the judges had. This is Judge Albright, so he had a bit more on average than the others, but it's a pretty even distribution of cases across judges. There's a drop. These are new judges. These are senior judges. The senior judges can more or less say, I want to work, I don't want to work, and the new judges enter the data a little later. Okay. All right, and these are the case filings in the Waco division and other divisions in the same district. San Antonio is another division, Austin's another division, Midland's another division. It doesn't seem to be that plaintiffs moved from one division to another division. No, they actually, we see a relatively stable case count in all the other divisions within the district, but the drop in cases in the Waco division. So if we take this one step further, and now we try and compare what's happening in the Western District with what we call a synthetic court. So what we do is we take the patent case filings in the next 10 most popular districts in the US for patent enforcers, and then compare their case filings. Western District in Texas, Western District of Texas, again black. The gray line is our synthetic control court. Pretty stable here. Not really a movement from the Western District to the other districts, yet we still see that drop. And that's what we want to eventually identify as that difference in difference effect. If we run this as a event study design where we look at the court month level data, we see the same thing. There is a bit of a peak in June 2022. One might think, oh, that could be an anticipation effect. There doesn't seem to be strong evidence that anybody was aware in June that Garcia would come down with the July order. That June 2022 peak here is Edge IP. They just had some idiosyncratic filing behavior. When we take the Edge IP out of our data, the effects still prevail. Then the peak's gone because that's Edge IP, but the effects that we show are still there. All right. So what we're looking at is now the overall impact on case filings and judge shopping. We look at it in two different ways. The first one is where we ask the question, did the number of cases filed in the Western District change following the random case assignment relative to all other district courts? So that's a simple diff and diff where we throw in, are you in the Western District? And is this after the random case assignment? And then we also look at the direct mechanism. We look at, did the lower case share that was assigned to Albright reduce case filings in the Western District? Because that's what the random order is all about, a smaller share, a smaller probability that the case ends up with Albright. And here are our regression tables. You guys, oh yeah, plenty of screens. random case assignment reduces monthly average case filings in the Western District by about 2/3. And it's similar, almost the same number for NP plaintiffs, for non-practicing entities. So this is the cases for all plaintiffs and for NPEs. The binary variable or the case share both give us roughly similar or roughly the same numbers. All right. So cases drop by about 2/3. Is it because plaintiffs leave the Western District, or is it because those plaintiffs just file fewer cases? So we want to know something about the extensive or intensive margins. When we split up the plaintiffs into three, we can split them up into three groups. The largest group here is the groups of plaintiffs filing in the Waco division only before the random assignment order. So that's the light gray. It's a little hard to see. Those are the plaintiffs that file only before the random order in the Waco division and then stop filing. But the smaller groups are those that file before and after, or that start filing after. I mean, it's not crazy to think that there are some new plaintiffs that file after. It's the largest group that does it only before and then leaves the Waco division. So that speaks a lot in favor of there's an enormous extensive margin effect happening. So is it extensive or is it intensive? We look at the reduction in the number of patent enforcers that were willing to file suit in the Western District. And we also look at the reduction in the number of cases filed by existing patent enforcers. And so for this, we restrict the sample to cases that were filed in the Waco division of the Western District. And we focus on changes of Albright's courtroom only. And here, the effects that we see, so both at the extensive and the intensive margin, an effect on both ends. So we see that the number of patent enforcers that were filing in Waco drops by about 69%. The number of cases per active enforcer dropped by about 78%. So plaintiffs leave, patents leave. Which plaintiffs do leave and which patents leave? And this is where in the paper we have a small model about the choices of plaintiffs to choose the Western District or an alternative venue, and that model informed our empirical approach here where to look in the data. So what we're doing is now we regress whether a case was filed after July 25, 2022, and we regress that on patent, plaintiff, defendant characteristics. We just want to know the composition of all the cases that were filed. Are those more likely, do certain patent, plaintiff, or defendant characteristics make it more or less likely that a case is being filed? All right, two types of results. First, the model suggests that there are losses from invalidation that drive cases out. If you think about it, intuitively, Albright's really great for plaintiffs. Doesn't want to invalidate your patent, doesn't want to invalidate your patent, doesn't want to delay litigation. If you have a very high value patent and you rely on those revenue streams from licensing, and there's the risk that somebody, now not getting Albright anymore as your judge, that increases the probability that the patent's being invalidated. The high value patents are going to stay out of the Western District because it gets risky to file a case in the Western District. The same is, and that's Joachim's point, if you have a low quality patent, one where you might expect this could be invalidated because it's of low quality. If you have a low quality patent and you now know you're not going to get Albright with a probability of 100%, but only with a probability of, let's say, 11%, some flip of a coin, you're less inclined to file the case in the Western District because the risk has just increased. So it's the high value and the low quality patents that are most exposed by this local policy. And we do see that patents that are asserted after the order are of lower value. For instance, we use proxies of family size, forward citations, technology classes for that, and they also tend to be of higher quality. So the patents that are asserted that remain are the higher quality patent. The low quality patent left the Western District. How do we measure higher quality? We use proxies from the literature, more claim narrowing during the prosecution, a lower examiner allowance rate. We take as proxies for that's a higher patent quality or lower probability of invalidation. All right, so that's the first type of result, which types of patents leave the district and which types of plaintiffs leave the district. It's a better outset option pulls cases away. If you have a better outset option, if you don't need to rely on forum shopping as much, or there's another forum you can go to that you perceive as almost as good, cases or plaintiffs tend to leave the Western District more than those that don't have these options. One that we're looking at is if the defendant is a publicly traded company, it's typically incorporated in Delaware. Delaware becomes a venue. If Delaware is a acceptable venue, then those plaintiffs will move their cases to Delaware. We see a tiny uptick in Delaware, but it doesn't explain the entire loss of plaintiffs there. So some plaintiffs move somewhere else, so other plaintiffs just leave. All right, last result, it's the judge's effect. So we want to know, why is Albright preferred by patent enforcers? Well, he's more favorable. Is it the motions practices? Is it the scheduling? Is it the case outcomes? A simple comparison doesn't work because plaintiffs select into Waco because of Albright. The random selection is going to do us a big favor here, because now we can look at what happens to the cases that are eventually randomly selected or randomly assigned to Albright. So we estimate the causal effects on the motions practices, on scheduling and case outcomes, and it's a randomly assigned cases that are filed in Waco after the order. Results are now relative to the other judges in the Western District. So take all the other judges in the Western District, the results we see is that's the effect of Albright. He's being randomly assigned to a case. What we find is there are fewer motions to stay or fewer motions of having patents invalidated on subject matter eligibility grounds. So a case that is randomly assigned to Albright sees fewer of these motions, and that's what plaintiffs like. We also see that Albright's patent cases move through, or at least the scheduling is 20 to 30% faster than the average schedule adopted by other Western District judges. If plaintiffs prefer faster trials or faster procedures, then there is an argument for we do prefer Albright because his processes are faster. They don't seem to settle more. It takes cases longer to settle, and then we look at the settlements more specifically. Is a case being settled or not? As far as we observe it through our outcomes of August 2025, we don't seem to see an effect of Albright on the probability a case is being settled. But we also observe anecdotally that many Albright cases are dropped relatively early. A plaintiff sees, oh, my case is being randomly assigned to Albright. A lot of these cases are dropped within the first 30 days. Cases that make it through the Markman scheduling order, so cases where the serious cases, for the lack of a better term, those cases, the Albright cases are settled more often. And that's again the idea that Albright prefers settlement and plaintiffs do prefer settlement. That's why they have a preference for Albright. All right. Okay, there's a black one. Okay, summary, case filings drop both at the extensive and intensive margin, and patent plaintiffs prefer the relatively fast pace by Albright. We build on other literature. What we add something on selection, which we don't suffer from. It's a judge and not just a forum, so there's something about limiting not just forum shopping but judge shopping. And while these random assignment orders do work, there's a policy story to this, but not anymore for Judge Albright because he's stepping down in a few days. All right, thank you.
All right, great. Well, I didn't get my slides up here yet.
You see it?
Yeah, well, thank you also for putting me on the program and putting this all together. Okay, so I'm going to, I don't really know how to put up a title with two titles in it, but I'm going to cover these two papers. I'm mostly going to spend a lot of time on the Albus paper just because it's more of my kind of stuff in there, but I'll say a little bit about Bernard's paper as well.
But generally, we've got these two papers. They're both motivated a lot by forum shopping. I think a lot of people know a lot of policy concern about patent cases in general, and how can we improve patent policy, and the fact that there's so much variation across different jurisdictions, even within the United States, gives us this kind of leverage to study different policies. And then this kind of forum shopping is both like a feature and a bug for that. It certainly gives like a lot of outsized influence, because you can imagine once a district adopts this kind of pro patent policy, then everything flows there, but it creates this endogeneity problem, what we see there. So anyway, both those papers are kind of getting into these issues, both of the policy implications of this variation, and also like, how do we measure the effect of it in light of this. So I'll start with this kind of structural approach, and then at the end I'll come back to, here I'm thinking of Tommaso's paper, and then I'll come back to Bernard's paper at the end. So, when I think about alternative policy regimes, a structural approach is a common tool, or an attractive tool. In light of this, the big issue, and you kind of saw it, I think, hopefully pretty clearly in Tommaso's presentation, is that most of the models that we have of lawsuits and bargaining and settlements rely on something about asymmetric information. Right? And so that means we have to have a model. In our structural model, we have to learn how much asymmetric information is there. We need to know, like, if in Tommaso's model, the plaintiff has private. So one of the issues in these models is you can think of it as sort of bargaining, and as many of you know, like in the kind of classic bargaining models, everything gets resolved in the first stage. In the very first period, you kind of reach an agreement, and then because it's inefficient to keep bargaining and have the pie get degraded. So already, here we're going to see things happening over time. Now you need a model, and it's maybe not that easy of a model to think of, that's going to generate the bargaining taking all this time. We need something that's going to drive that, and here it's going to be uncertainty. And there's different models out there that you could that kind of generate time. We could talk about a little bit about the alternative paths. You could have chosen, but you chose one that's very common in this kind of lawsuit literature, for lack of a better name, where one side knows more than the other, and the other side's kind of making settlement offers and trying to figure out what's going on there. But what's going to really drive this outcome is how much does the uninformed side know about the informed side. If the uninformed side had like near perfect information about the uninformed side, they could all just reach an agreement really quickly. We'd get exactly the right settlement kind of in the first period. Now there's going to be this uncertainty, and we have to like estimate that uncertainty. So actually I love this feature of this literature. I think like these models of asymmetric information are really, really cool. When I've taught many of these kind of bargaining papers in my class, because I just think it's a really interesting problem to think about, but it does bring up a bunch of issues. So I'll just say a little bit about, here just a quick review of Tommaso's model. We've got continuous, infinite time. It starts off with the plaintiff kind of making this claim of damages, everybody knows that. And then at any period, it's in continuous time, but at any moment, the kind of game can end for two reasons. Could be the plaintiff wins, could be the defendant wins. And those are two separate, independent in this game, probabilities of this happening. And if neither of them hit, it's like these two separate kind of hazard rates. And if neither of them hit, then they just keep going for the trial. And these two probabilities are governed by these two parameters, lambda and rho. Lambda is the kind of plaintiff probability of winning, and that's known to the plaintiff but not to the defendant. So that's where this kind of information problem is going to come from. There's also the probability the plaintiff loses, and that's governed by this parameter rho, and that differs across districts. That's going to give us the heterogeneity. It's known to everyone. That was a really clever way to build this in. I don't think you see this in the other kind of litigation models that I'm familiar with, this kind of probability of the plaintiff. It's kind of, most of the other models have like one period or a set number of periods, and then the trial happens at the end of that. And here, it's kind of a very different approach, which I thought was really interesting. But it's this lambda thing, which is going to generate the asymmetric information. So the plaintiff knows lambda, the defendant, that's the probability of winning. The defendant doesn't know it, and the defendant's going to be then making, okay, so then at random times now, the defendant gets to make these settlement offers, and the defendant, the plaintiff kind of accept or reject them, and then the defendant's got to like learn about that. So, the defendant's got to kind of learn from that. Okay, and then there's some flow litigation costs that are kind of normalized relative to the claim, and as we talked about, but the plaintiff can also drop the case. That isn't turn out to be very important for what we're doing. Okay, so this kind of, so at the beginning of the game, the defendant knows lambda, sorry, the plaintiff knows lambda, the defendant doesn't, and there's going to be some distribution that lambda is drawn from, and that's going to tell us how much asymmetric information is in the game. So just right off the bat, there's almost no trial, almost nothing ever gets to trial, right? So that tells you basically by the end, the asymmetric information is basically resolved. Like that, you know now, just from that fact, the plaintiff is gonna, the defendant's basically gonna figure out lambda. But there's two ways to get to that kind of ex ante information revelation. One is there could be very little asymmetric information. Could be that lambda is drawn from a really tight distribution. Right? So the defendant knows that a priori they only get to make one offer. That could generate this outcome of like no trial. Another way to do it is you could have lots of ex ante information, but many offers. Like the plaintiff, the defendant's in there with lots of lambda kind of working their way down, and that sort of Coasian dynamic that Tomas was anticipating. And to me, those are very hard to separate. Like, and I guess that's kind of the question I would leave for Tomas is how do we think about how these would be, how would we know that it's one or the other? And so, just to kind of go back to the model, in his model, lambda follows a beta distribution. That's the kind of probability of winning. Then the time to an offer follows a normal distribution that's truncated at 0, so it's positive. Okay, so those are the two things, the kind of frequency of offers and the amount of uncertainty. And both of them have these two parameters in them, 2 parameters each, so there's 4 parameters there. And then the question is like, how are these separately? So I would tell you to like maybe try to engage with that a little more in the paper. Like I would like to hear more about how you think of those separately identified. And I want to throw out the possibility that it doesn't matter. Maybe they're not separately identified, but maybe we don't care because at the end, like the real result is at the end, asymmetric information is resolved. Like whether it's through lots of offers and I can imagine different approaches to this problem, but you kind of made the point with a different identification problem that you didn't care how it was normalized. Here, maybe there's a similar story to tell. I don't know, but anyway, I'd be curious how you think about that problem. So, and I want to be sensitive to like how Thomas must have lit off by saying like, oh, so you want all this work with paper? I need to finish the paper, and I'm like, wait till you hear my discussion. So hopefully this is like in the range of stuff that's not that hard to do. So yeah. I guess another question I had is like, does it matter? So the fact that the plaintiff knows and the defendant makes the offer is actually different than maybe the previous paper. So like C, which you kind of references in the paper, is the opposite. It's like the defendant knows the truth and the plaintiff makes the settlement offers. I was kind of curious if that made a difference, but because I wouldn't dwell on that one in the thinking of getting this sent out. And so the results are really cool. Also, I just want to say I'm skipping over tons of like awesome work in this paper of like kind of deriving the equilibrium and kind of reducing the state space and the whole estimation algorithm. And I wish I could. Anyway, I'll just say all that. That was really cool. 5 minutes. Okay, yeah. So that's fine. And then there's not much in the presentation and a little bit in the paper about kind of like a socially optimum. Can we compare to a social optimum? Like there's a lot of comparing kind of the outcomes that we get in the data to what would happen in the counterfactual, but it's kind of hard to say whether those are better or worse. Like even after both these papers, I'm still sort of wondering like, maybe Judge Albright was right. Maybe it should be plaintiffs win every case. I know everyone like harped on him and the Economist and everything, but I don't know. I don't have like a strong prior about how it should be. Anyway, and it's a little bit hard to get to. One thing I was wondering like is like a kind of no asymmetric information benchmark, a way to like anyway. You didn't really talk very much about kind of the social optimum, so I won't go on that. But I did wonder, yeah, with regards to this identification question, do they play a role in the counterfactuals that we get? Let me talk. I have just one slide on Verona's paper. It's also really cool and really well presented. But maybe I'll talk more about the slide on this one because I only have one slide on. So basically we're going to regress the number of cases in the jurisdiction. More or less, there's a couple other types of regressions. We're going to regress the number of cases in this particular jurisdiction on this policy change that made it less attractive to plaintiffs, and see the effect. Effects are huge. It's just enormous. Like the number of cases dropping down, it's like eye-popping. And I've also heard stories all about. I mean, one thing you didn't touch on is like, was there something nefarious going on? Like I've heard all these stories about like hiring Albright's brothers law firm to, help you prep your case, and yeah, like you talked about Samsung. I mean, the Samsung thing, I guess, was building an ice rink is, I guess, part of that. But there's kind of like some kind of pretty weird stuff about it. Anyway, the effects are huge. I'll say, it's a differences in differences design. So you're trying to compare this particular district to all of their districts. And you would think, like, as the number of cases go down in this district, they go up elsewhere. And so then that's, maybe it's not a perfect control group in that sense, but it's still, like, a really interesting result. I'm not sure that we care, what should be a combination of effects. There's some evidence kind of that there really was no increase elsewhere, like, which is really surprising. I guess that would suggest that there's, like, a real drop in the number of cases filed. So two questions about that. I guess one I wondered is, it seems to me if I was like this PAE who was only going to go file the case, if I was going to get Albright, you can still file it. You can still file in the district, find out who you got assigned to, and then drop the case, right? You can kind of like, and I wonder if it can detect any behavior like that. Like, couldn't you just go and take your shot, and as soon as you didn't get one of the other guys, kind of walk away, and if there's any cost to them for doing that. And then, yeah, and so then, like, where did these filings go, I guess? And there's some suggestion, but you didn't totally, I feel like you didn't try to pin that down, like even like a national number, like a national number of cases. Did it change afterwards? And then there's, I think the other thing that's really interesting, I find, like, patent lawyers, like, their strategy set is so enormous. Like, I find it almost impossible to think about. They have many jurisdictions that they're filing in. There's, like, different countries. You have international damages you file in different countries, and then there's these other alternative things like the ITC and like arbitration hearings. It's very, and then they're playing this game where like you're doing well in one jurisdiction, and you might think that like the outcome in one jurisdiction affects the outcome in another jurisdiction, even just by consequent of judge reading of the outcome, even if there's no real precedent there. So you're trying to like push the cases where you're doing well in, you're trying to move them along, trying to throw sand in the works for the ones that you're not doing well in, the other side's doing the opposite. It's really complicated, but I wonder if there's any way, and I guess this would be a different paper, to kind of to leverage this change for international implications for other jurisdictions like ITC or something like that. Okay, I'm going to stop there. Thank you very much.
Thank you, first of all. On the question, specific question of the separate identification, if I was only observing the hazard rate of settlement, I would not be able to separately identify. But the tau, the delay between meetings, only affects the strategy, the settlement rate, without affecting the win or lose rate, right? Conversely, the distribution of lambda affects all three. I mean, all two, like not the. So that's how I can get the separate identification. But you're perfectly right, because right now that part is not explained very well in the paper, because I have zero incentive to write it better, because I'm changing the. So it's totally my fault. So and I add that also the point will be mute because I will observe the meeting times. So tau will now be directly estimated even outside the GMM. So that's, but you're right. So the intuition is correct. If I were only to observe the settlement rate, I would not be able to separate and identify them. I have three distribution. And on the benchmark, yeah, you saw I did that thing at the end on welfare. Tried to, I actually something I can do is in principle. Suppose we have weight between how much we want to be right. We put a weight on just giving the right probability of transfer of winning for case deserve it. And on the other hand, we put a weight on the defendant's welfare. So essentially, or like total. Let's say we can do two types of mistakes. One, we can get the case wrong, and that's bad because we believe that wrong cases are wrong, like a wrong decision are bad. Or we can do another type of harm, being we just increase cost, and that's bad for society. In principle, I can. That would be a welfare criterion, and at the court level, that could be a parameter that I can try to estimate. That is what's happening in the last section. I don't know if you thought that was interesting as a way to respond to what would be my benchmark, my welfare. But yeah, sorry. But thank you so much.
Thanks. Huge effects, yes, but I think it was Arvid who had that suggestion or response for an early iteration of the paper. Why is the effect only 67%? The probability of getting Albright is 90%. Shouldn't the cases drop by 90% if plaintiffs really love Judge Albright? So it's a big effect, but I don't know what to take. Is it too small? Is it too big? We did look a little bit, as you said, and I think I try to point at a couple of things in the presentation. It doesn't seem to be that cases go elsewhere. There's a slight uptick in Delaware, so some cases do go to Delaware. It's not that all of these cases go to the Eastern District. The Eastern District picks up a few of these cases, but doesn't pick up enough. Some cases are just lost. There's a bit of anecdotal evidence that plaintiffs still bring cases and then look at who do they get, and then if it's not Albright, they just drop the case. But that doesn't explain the drop either. So that's just those are anecdotal cases, and it's just a small number. Christian and Brian had in their earlier paper, they show this uptick of cases, and they argue sort of the counterfactual. If it hadn't been for Albright, a lot of these cases would have never been brought, and it's kind of now that the random case assignment order now eventually kills those cases. Those that would have never been brought now are just not brought anymore. On welfare, I don't know. I think there's an argument for specialization. I guess there's a good reason why all appeals cases end up in the same court and not in the regional, federal, regional appeal circuits, but just at the circuit of the federal, or the Court of Appeals of the Federal Circuit, because of specialization. There are other specialized courts. I believe there's an argument maybe in your jury pool to be more tech-affine, and the judges. Specialization could have benefits. We try not to make any welfare claims about good or bad, but think it's as welfare neutral as we could have been. If there is a cost of lengthy litigation, Albright's good. He seems to be speeding up cases. That's a good thing. And last, international jurisdictions, I think that's an intriguing question. I just don't know enough about co-filing strategies. We briefly talked over the break. I guess there could be arguments to be made if something happens in U.S. courts and there are twin patents, and then the European judges have to think about the validity of the EPO patent. I don't know how the contamination would work, but some of those kinds of strategies could play a role as well. Yeah, thank you.
Thank you. Really two fascinating papers. I have a question regarding Tommaso's. You're making the assumption, and you actually said the plaintiff naturally knows lambda. I doubt it. And I wonder how important that is. And I doubt it. It might even be the other way around, because in the end, to know a patent that somebody has, that's one thing. And that's even for the defendant, that's easy to analyze. But what that patent does within the products or the organization of the plaintiff, of the defendant, that's I think, much more complicated question that the defendant can actually answer better after some research than the plaintiff. So I think I'm not so sure about your assumption there. And I'm wondering how much effect that has, is, if any. Another smaller comment is that you said information comes through decisions. In Germany, at least for the patent court, we have a specialized patent court. They give so-called, it's called qualified, what's it called? Qualified indication or something. Qualifizierter Hinweis in German, which then often leads to settlement. So I'm not sure. Well, of course, it depends what you can observe, but it's a lot more than just decisions, I suppose. What's affecting settlement?
So, may I? Sure. On the first point, no, absolutely. So, should I have a model with two-sided asymmetric information? Yes, there's definitely asymmetric information on both sides. Can I solve it? No. I don't think that model can be solved with two-sided asymmetric. I don't even Tirol could solve that model with asymmetric information. Then you make a fair point. It's like, who should have the asymmetric information? I chose the plaintiff because it's very natural then to think about the decision of filing if the plaintiff knows how good is the case. They choose the case, they choose the victim, they know the patent. It seemed natural from that perspective. Now, the defensive answer to your question is, suppose we keep one-sided asymmetric information. Now the defendant knows the lambda. And is the plaintiff making the offer? I get exactly the same type of equilibrium. The estimate might change. So I will, because I know this is going to come up again, I will estimate the very same model with a flip asymmetric information. Both, I definitely cannot do it, and the estimates will change. I don't know by how much, but that is something I can and will do, for sure. On the second part, I don't understand the question. So,
if I understood correctly, then the information flows to the parties through decisions. And my only point was there's more information flow than just decisions. Formalized, but also informalized, obviously, but that you can't really.
Okay, so the model assumes that at each epsilon time, or each step of time, there is the lambda or the raw probability of something happening. And time can be a day, or can be a page on a PDF, let's say. Like that, because that's the flow cost for lawyers. I can measure time in those two ways. What I need to assume is among the actual documents I see, which one are likely to be documents in which, hearings were moments where both lawyers were there, and if I don't see them settle, means that they decided not to settle. As I've been watching 8 seasons of Suit to find very good quotes for the occasion, and season 7, Jessica, I don't remember, says every meeting is a settlement meeting. I don't know if so that's my answer. Every time, my observed moment for a potential offer is a hearing or any docket generating step where I know the both lawyer. But information is flowing either with pages of PDF or time. Yeah.
I have a couple questions to ask. I mean, one for each of you, but if there's time. But one on the pattern of forum selection, and we've had another big event beyond Judge the elimination or the institution rather of random assignment. We've also had the significant weakening of the inter partes review procedure in the last year or two with the Trump administration, and I see that playing a couple different roles in forum selection. One is now, if invalidation is going to happen, it's much more likely to be happening as a result of what happens in the courtroom and not what happens in the patent office, on the one hand. But on the other hand, one of the reasons you might favor as a plaintiff a particular judge is because they will not grant a stay in the event that an inter-parties review is instituted, and now those are much less likely to be instituted. And I'm wondering if your data sets and techniques can be readily adapted to discern, whether these effects are happening and how they play out. How does the impact of these IPR policy changes affect the pointiness of forum selection, or spikiness, I should say.
I propose we just take a couple of your questions and Lisa's, and then but you had one for Tommaso, you said as well, no?
Yeah,
All right. Well, let's get it out there. Then
Okay.
Everyone can figure out the answers over a drink.
Okay, sounds good. That's right. My question for you was about PAE behavior and how their settlement behavior may vary depend on the financing strategies behind them. I mean, some are independently financed entities that can self-bankroll litigation. Others are relying on litigation financing, contingency lawsuits, and sometimes, I mean, as we know, a lot of these mechanisms are not transparent to the defendants. What are we dealing with as a defendant when we're negotiating settlement with a plaintiff? How hard are they willing to fight? And I'm wondering if this kind of data actually could be put to use in analyzing the behavior, because there are many large-scale plaintiffs that we don't really understand maybe what's behind them. Can we look at it from a data standpoint and figure out, what their strategy is?
Hold your thoughts.
So this is also for Tommaso. I mean, the general point is I think it'd be useful to send this to some U.S. law professors just to think about their perspective on things. I mean, I share the concern about where the asymmetry is, and that I think that defendants will have generally much better information about their non-infringement defenses, and it takes time for plaintiffs to get that. And you already responded to that point. I think in practice, often the plaintiff often makes a specific demand, and I think you are assuming the defendant's always the one making the offer, and so I don't know how that affects things. And I'd like to talk more maybe over our drinks later about just the kind of assumptions you're making about the what we can infer about quality from the duration of litigation. I'm not sure how you, or the likely settlement category in Lex Machina that includes no payment dismissals, and does that affect anything in your results? But you have no way of knowing whether they involve payment or not, right? Yeah. And then you describe your forum shopping counterfactual as the appropriate venue according to the T.C. Heartland rule, which is not the rule, so I would describe that differently. And your description of the fee shifting counterfactual, I think, is also not assuming the right current rule. And frivolous is a legal term of art, so I would choose a different term.
We're running 10 minutes plus over, but that's fine. That means everybody's interested. Thank you all for staying with us. I would invite you all upstairs to, we have a few hors d'oeuvres and cocktails. I believe on the 4th floor. I'm gonna look at it. It's on the 4th floor. So thanks. The 9th? I think no. I think she's out there. All right. She will be directed by the person standing outside the door. Okay, and that's it. Thank you, everybody, for participating.